because all his other bond work was covered as Mayor Scudo. All in favor say aye. 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 5-0. The direction is for you to draft the RLI. Let me move to another issue on this. And as you know, I raised this issue on September 13th. And at that time, it was a matter of also having spent the better part of the last 4 to 5 months listening to residents expand or request that we expand our consideration of the city attorney. At that time, in contrast to what some of the comments I heard up here, I'd never once heard anybody say anything about Eileen Lieberman. If anything, it was in spite of the fact that she represents part of Sunrise that we're doing this, and I also heard about hard decisions at the last meeting. This began as a perception issue for me, in that it was clear that people felt the process was often as important as the result, if not more important. After that began, and I had some lingering questions that had been raised with respect to the utility bond deal. As you know, when I came into office, staff had to bring me up to speed. Many of you were already up to speed on these issues. And they sat me down on the bond deal issues. They gave me the numbers broadly, what the scope and why it was. And there was an area about professional fees that I asked about. How much is how the lawyer's getting, how much are the underwriters getting, and they provided me in a broad sense. But it didn't give me the names. At some point, I got the names, and what I found was that Mr. Michelson was getting a $45,000 fee out of the bond deal. My efforts to try to understand what that was have been less than satisfying. I have spent some time in communication with staff. I've spent time in communication with Mr. Michelson. We asked it on September 13th, and I have heard a number of different justifications for it, none of which I believe are compliant with his contract. The justifications I've heard are that the $45,000 was for the purposes of purchasing insurance. I reviewed the contract. First of all, the contract has two options for the payment of Mr. Michelson. One is, if it's a contract service at a city attorney, it's $36,000 a month. And that covers all of the expenditures by his contract. If it's services other than the contract services, he goes to $225 an hour. There is no third option. So as I began to look further, I also tried to find out whether there was a provision for insurance. And there is no provision for insurance. That is, we do not pay Mr. Michelson's malpractice insurance for his other than contract services. We would never do that for any lawyer. We never separately billed. So when I heard that it was for insurance, I went and reviewed the risk management file. And what I learned was that the city had actually acquired insurance to cover Mr. Michelson for this issuer's letter. And to put in some context, it's a letter that was provided by outside counsel in a template form for Mr. Michelson to sign. Since Mr. Michelson had never done this before, they gave him a broad template. For signing that one letter, because all his other bond work was covered as city attorney, he was to receive $45,000. When he said the $5,000 had been spent for insurance, it turns out the city was able to obtain that through the League of Cities, making Mr. Michelson a named insured. So the idea that somehow this was for insurance had to be questionable. Mr. Michelson indicated to me that this was because he was concerned about tail coverage or risk going forward. So I reviewed the insurance policy. Something I do on a regular basis, Mr. Michelson does on a regular basis. It's an incurrence policy. That's different than a claims made. That means the policy is triggered by the act, the occurrence. There's no need for tail coverage. If you had a claims made policy, you'd worry years later that the expiration of your policy, you'd need a tail. So there was no reason to receive that $45,000 for insurance. What I was told additionally that was considered was that because other lawyers had been given more money for doing an insurance letter, he was entitled to $45,000. I don't see the logic of that. With respect to any, let me just back up on the insurance. One excuse Mr. Michelson gave me was that, what if the League of Cities fails? What if the insurance fails? What if our relationship with them fails? They've been around for 25 years. Our entire risk management structure is centered around the League of Cities. It's fanciful, imaginative to think they're going to fail, but more importantly, the $45,000 wasn't tethered to that risk. So as I dug further, all I could find was that there was absolutely no justification for that $45,000 fee that was neither based on his contract, which had two options. It was not based on insurance. It was based on either this body didn't understand or heard from Mr. Michael something different, or he individually convinced everybody it was for insurance. In either event, there is absolutely no legal justification or basis for that fee. It is not based on contract, and as a result, I've outlined for Mr. Michelson my very clear objection to that $45,000, and I have a detailed memo that I'm prepared to provide each of the commissioners tonight, but it sets out provision by provision by provision that this was not something he was entitled to. If he entered into a contract with a city that had floated bonds in the past, that had existing bonds outstanding, and didn't realize he might have to sign an insurance letter, that's a benefit of the bargain problem. Okay? You don't get to go back and do it again. Now, I've not seen a modification of his contract. Perhaps it was modified by some ordinance. Perhaps this body agreed to it. But I cannot accept a city attorney who's advocating for himself to get more money in the face of $430,000 plus another $57,000 on outside contracts, and yet another $45,000 that is in no way supported by the contract. Now, I heard about hard decisions. This is not easy for me. I know Mr. Michelson, and I like Ms. Kislin. This is not easy. But that decision of Mr. Michelson to obtain money that I don't think he was entitled to have convinced this body that he was entitled to it, and to give varying excuses, frankly, has undermined my confidence in him. It has undermined my confidence in what he can do, to the point that I now have to feel I have to watch the billing and I have to watch other things. Now, my concerns did not end there. I reviewed the pool claim file. And I have to tell you that I am very disappointed in how that was handled. I have reviewed the risk management file of this, and it appears to me...
Mayor, can I respond to the remarks you made about...
when I'm done, Mr. Michelson, you can, but I want to make this clear. I'm happy to cross-examine you on the fee, because I've been trying to get to this. But there...
Wait a second. Point of information. It's 11:45 at night. We've already voted to put his contract out. Can we just discuss this at the next commission meeting?
I'm happy to do it at the next commission meeting. And you know what, Deputy Mayor Lou, that's fair enough. And here's what I'm willing to do. Because pursuant to the contract, because this is what I'm going to do, and I've informed...
Just a copy of what you have.
I've informed Mr. Michelson, excuse me, I've informed Mr. Michelson of what I intended to do, pursuant to his contract, Section 11 of his contract, which allows for a motion to terminate the contract to be considered on 10 days' notice, that it will go to the agenda, and then consideration. That's what I intend to do. And I'm going to give you the basis, and you guys can reject it later or accept it, or be part of the RLI. But based on my review, I am going to, and here's the memorandum on it, I'm going to be moving in 10 days for this to be put on the agenda to terminate the contract for the reasons stated herein, and pursue to a Section 11 hearing if he's so inclined.
Okay, even though I didn't want to sit here and get into this, seeing how you've made it publicly known that you want to terminate the city attorney, I'm going to respond briefly. One, on the $45,000 fee for bond counsel, I was not thrilled with that fee or any of the fees that bond counsel has charged the city. I was shocked to find out how much money all the attorneys made on outside bond work. But in speaking with Mr. Nevins, found out that Mr. Parkhurst made $400,000 on bond work back in 1970s. I remember being ill. I was home from work. Mr. Michelson said, I need to speak with you. He went over the reason why he was charging the fee. He went over and gave, I'm assuming, each of us a survey of how much money Sam Gorin has made equally, even though Sam Gorin has a contract that's an hourly rate.